The following is a legal advertisement from Gwendolyn J. Sterk and the Family Law Group. This does not constitute legal advice and should not be construed as such. This podcast is for informational and educational purposes only.
Hi, this is Ragan Freitag with the Gwendolyn J. Sterk Family Law Group.
And I'm Gwendolyn Sterk, and today we're going to talk about the process of contested parenting matters in litigation.
And how this begins, when it begins, and when it hopefully ends.
Well, yeah, and it can be a long process. So we're going to try to walk you through certain of those steps because just having that terminology can be helpful throughout your litigation. So how do you start?
Talk to your lawyer first.
That's right. Sometimes we think we start with the initial process, but really you need to talk to your lawyer because you have to have a plan going forward, especially if you know that you're going to have a contested parenting issue, and even if you don't, there has to be a thorough agreement and you have to have an understanding of what your rights are.
And it's important to be honest with your lawyer. Tell them everything. And that means even some of your flaws or your issues that have happened and your expectations. So moving forward, you're happy with what's going on.
Right. And the other thing that's a concern these days is, and we'll talk about it in a separate podcast, is July 1 of 2017, we have a new law in Illinois about child support, and it counts and varies the support if you have 146 overnights. So that has changed the environment of dealing with these allocation issues.
So once after you talk to your lawyer, what happens next?
Well, you really should file a petition for dissolution of marriage, or if you're in a parentage case, you'll file the appropriate motion, and in that motion you'll ask for the allocation of the decision-making responsibilities, and you'll also ask for the majority of parenting time within that structure. So you have to have some form of a pleading on file in order to move forward.
When you say allocation, now that's the new word that we're using, right? Not custody anymore.
Right. Custody is now considered a bad word in our environment. So is visitation. So we're talking about the allocation of parental responsibilities and parenting time issues. That's what we're talking about in terms of parenting matters.
And what's the expectation of when we can get that filed and get that agreement before the judge?
Well, it's a long process. So first, you have to put that pleading on file, but then our law now provides that you have to come up with a proposed parenting plan within 120 days of that initial filing. So that's something that you'll put together and work with your lawyer on. But that can be hard to do because if you don't know where you're going to live, you don't know what your schedule is going to be, that's a little bit of a pressure point to take care of it early on. I understand why the court wants to do that, but for some people it can be difficult.
What in the world do these people do for 120 days if they don't have an agreement?
Well, you can file a motion with the court. If the two of you can't reach an agreement, you can deal with the temporary matters and have a temporary schedule put in place. And under certain circumstances, the court will send you directly to mediation.
Have you ever had a client just say, I want to get this done, I want to sit down with my husband and or my wife or even another attorney and do a four-way conference?
Sure, you can do that. And what we like to do is draft the parenting plan as soon as possible. It's my belief that by seeing what issues have to be addressed, it gives you the full framework. And we have a longer form and a shorter form, but depending on that level of tension and the detail that you want to get in there, I think that even before you do that, before you sit down, is to have that proposed plan so that you're seeing all the issues.
And it sounds all nice to just get this done and get along and sign off on things, but as we know, Gwen, that usually, unfortunately, doesn't happen. So there's other steps that can be taken thereafter.
That's right. And the first one is mediation, where the court really wants you to sit down with a mediator. Now, remember, those mediators on the list, they can be of two different varieties. They are trained attorneys who do it, or there's also some counselors on that list. And depending on the history of it, sometimes I prefer to send clients to a counselor for the mediation because perhaps they can see other issues than just what's being dealt with in the parenting matters.
Is there a cost difference between those?
Not necessarily, although generally I think that the psychologists are a little cheaper, but you are going to pay for that, and the counties are requiring that mediation process.
And so if they don't resolve anything in mediation, the next step would be sometimes to get what's called a guardian ad litem, correct?
Yeah, it can be a guardian ad litem or it can be a child's representative. And depending on what county you're in, the courts may be inclined, depending on the county, the age of the child, to appoint one versus the other. The guardian ad litem is somebody who really becomes eyes and ears of the court. Wouldn't you agree?
Yeah, I would always tell my clients, this is the person that's more or less your child's attorney. They're there for the child.
And the GAL is looking out for what they consider to be in the best interest of the child. Now, they're not necessarily for a teenager advocating for what the child would want, because that would be the role of the child's representative, where you use both models, meaning that they're really the attorney for the child, advocating for what the child wants, and in addition to that, you are comparatively advocating for what you believe is in the best interest. But it's interesting because the GAL and the child's rep has to be an attorney and cannot be a psychologist, unlike the mediation process.
And they go through a pretty extensive training and continuing training on that, because we're dealing with children here. I mean, they should.
Right, and they are going to go interview the collateral witnesses. They're going to look at the school records. They're going to look at different issues that might be relative to the case, and then come up with recommendations that they work with for the court. They can give their recommendations to the court in a written format. They also, if they're a guardian ad litem, not a child's representative, but a guardian ad litem, can actually testify at a subsequent hearing, and then the court can allow you also to bring in your witnesses that might be consistent with the recommendations of the guardian ad litem or not consistent.
And judges really like them because they're almost an independent, unbiased person in the situation, because, as we all know, we advocate for our client. We are doing, our job is to be hired and to advocate. Sometimes, we are fighting for our client and the other side's fighting, but they're obviously in different opinions. And then the judge has this independent person that says, okay, but I went to school and this is actually what happens. This is the person really picking them up. And it's somebody that the judge can really depend on when making these decisions, which are important.
Right. Now, if you are still not able to reach an agreement with the use of the guardian ad litem, and if there are mental health issues involved in the case at all, the guardian ad litem's role, remember, they are not mental health advocates. They don't opine on that, and they are generally not going to be involved with that. So what you do is we can get to the next level where you can ask the court to appoint a psychologist or a psychiatrist that is going to be the court's expert, and that would be what we now call a 60410, previously known as a 604B, really evaluation person.
When you say mental health, is this when the child is having mental health issues or the parents?
Either side, anybody having mental health issues. There are some conflicts, and we'll do other podcasts on that, between the Illinois Mental Health Code as well as the Illinois Marriage and Dissolution of Marriage Act, because those crossing those lines and how that relates one to the other, as you can well imagine, the law can't anticipate everything. So there are some things that have to be dealt with, and you have to be real careful that you're not crossing those lines. And so the expert then, who is the psychologist or the psychiatrist, comes in to do that evaluation process.
And I think what people need to understand, this isn't you can have a mediator or you can have a GAL or you have this evaluator. Quite honestly, there's been cases where you've had all of them and you have to pay for all of them. These are expenses outside of the attorney fees. So these are a lot of decisions that need to be considered.
That's correct. And when the court gets to the point of looking at that professional evaluation, that evaluator is also going to generally employ psychological testing to determine whether or not there's any signs or issues that should be addressed or are part of the decision-making process as to what's in the best interest of the child. So it's important that you be honest with regard to that testing, and then that level of scrutiny really is intense when you get into those evaluation processes.
And some of these individuals, when we're talking about a mediator or a GAL or the evaluator, if there are mental health issues, if maybe there's physical abuse or there's anger issues, they can recommend counseling or classes. And again, we're talking about more time and money invested in this divorce.
That's right. And sometimes the necessity of that going on, because depending on what the circumstances that have led you into that point, when you're getting into that high level of conflict, there has to be some process put out there for resolution, because you have to stay focused on the fact that you're not just getting a divorce. If you have a child, you're with that child clearly through graduation of high school, then you've got college, and then let's not forget, your kids get married, they have their own kids. There's a lifelong process here. So I always say to people, don't be afraid necessarily of that evaluation process. Learn from it. There are things that we all can learn from about ourselves to teach us to be better individuals, and the court making that decision. I think it's also key that we talk about the fact that the arrangement of the decision-making process, it can be reviewed. Once you are awarded it, let's say you go all through the process and you win, it doesn't mean that you have that win, quote unquote, although I don't consider it a win forever. It can be reviewable every 2 years.
And these individuals then help you as the attorney and the parents and the children put the information into the allocation, correct?
That's correct. And then if you can't reach an agreement, ultimately the judge will make the decision. The other thing that I want to talk about is the context that if you're not happy with the evaluation report, the law does provide that each parent can obtain their own individual expert. That is their own self-appointed person. They name who that individual is. So let's distinguish between that. If the court's appointing their own expert, the court gets the choice, right?
Right.
But if the parent goes beyond that and either the judge didn't allow that evaluation to occur and they want an evaluation, or if they want it in addition to the court's expert, then essentially they can hire their own, who then will make recommendations to the court thereafter.
And how exactly are these costs or expenses paid for?
Well, if it's the court's expert, that's going to be divided between the marital estate. But if you get your own independent expert, you're going to be paying for it out of pocket. So this process can be extraordinarily expensive.
Wow. Wow.
Well, and if you can't agree, the judge decides, and then always remember there's an appeal process, which we'll eventually talk about as well. So that's what that process looks like.
It's long, it can be tedious, but just stay in contact with your lawyer and she can help you.
The proceeding was a legal advertisement from Gwendolyn J. Sterk and the Family Law Group.